Let's go.
Well, good evening, everyone. It is Monday, March 16th. It is St. Patrick's Day Eve. I'm William Kirk. Kostas Moros, how are you doing?
Good, man. How are you?
I'm doing well. One of these days, I'm going to get to do a live thing again from my own home location. We're at our Central Washington location today. And the last two live things we've done, I was in Denver and then Chicago, right?
A lot of traveling for you.
A lot of traveling. Yeah. So how things down there in Southern California? How's everything going with you?
Pretty good. I mean, summer hit this week for some reason, so it's been really hot. But, you know, other than that, it's okay.
We could use some of that around here. We're going to do something a little different tonight. This was your idea, and I actually liked your idea, which is rather than having guests, why don't we take some questions from our viewers? So we're going to go through about 15, 20 minutes of other stuff to talk about, and then we'll fill the rest of the time with questions from the viewers. And whenever we wrap up, we wrap up. How's that sound to you?
Sounds like a plan.
All right. First thing I want to talk to you about, United States versus Hemani. We have not been able to get together on a behind enemy lines since that time. We were able, as you know, to get together and do a pre-recorded thing and a video about it. But you and I both had an idea of how Hemani was going to go. And then we kind of came away from the oral arguments thinking a little differently. Why don't you walk everyone through your journey through those oral arguments?
Sure. I mean, I think you basically covered it. It's that when we came in, we thought, especially given the petition that was granted with these terrible facts, although the other facts weren't central to the question presented, we thought maybe it was an indication of the way the court was going to rule. And who knows, maybe it still might be if the liberal justices just hate guns enough that they'll vote against another one of their constituencies. But based on the questioning in there, I think we're coming away with a 6-3 and possibly even 7-2 win in this case. Now, the logic, the analysis is going to vary wildly. I don't think all 6 or 7 are going to join one opinion. I think there's going to be concurrences, and it's going to be a bit of a mess with the liberal justices talking about interest balancing and why Bruin's bad. But at the end of the day, on the core question, and we shouldn't understate this, on the core question of whether people who use marijuana even regularly, it seems like the court's going to say you can't strip them of their Second Amendment rights, and that's important for a lot of people. So that's a positive thing.
I thought the court did a really good job. Anytime either side started straying off that very precise issue, especially the U.S. Department of Justice, when they wanted to start talking about Hemani's, less than reputable character, they kept bringing back to, well, really the only two operative facts is that when you searched his home, you found a Glock handgun and some marijuana. Isn't that the operative facts here?
Yeah, I mean, all this other stuff about Iranian terrorists and did he take promethazine, which isn't even illegal, but all this other stuff they tried to go into didn't even come up. That's what was most surprising to me. It didn't even, the DOJ didn't try to bring it up. The judges didn't try to bring it up. So that was a good sign for us because they are focused on the question before them. And I think, a lot of the questioning was really on point, like Judge Barrett talking about, like, forget marijuana. Like, what if you just illegally take Ambien to go to sleep? Does that mean you're dangerous? Or the questions about how when Congress drafted this, they clearly weren't talking about dangerousness. They were talking about whether these drugs are illegal or not for a variety of reasons. Maybe some make you dangerous, but maybe others are just bad for you. Right. It's not about that, oh, you're some criminal threat now.
Well, I think we need to differentiate between drugs that are dangerous to your physical health and then drugs that make you a dangerous person to others.
Right. That's exactly it. And Congress didn't really do that. So even if, and I think Barrett would be okay, I'm just pointing her out because she was the one talking about it. She would be okay with a categorical approach for dangerousness, but it didn't seem like this reflects any such category, So even if you're charitable with the government that they do have this power to disarm dangerous groups, Congress never made such a finding. So
the liberal justices seem to be actually okay on these, at least if we're going by the tone of their questions. What did you make of that?
Yeah, I mean, Justice Jackson continued her trend of bashing Bruin. You know,
Right.
I think that she basically and in a way that kind of misunderstands it, because she did kind of adopt the actually the Justice Thomas dissent in Rahimi, you know, which the court, whether we like it or not, has rejected. You know, the court has said, no, you can go for these broader principles. But Justice Jackson was acting as if, because they didn't ban marijuana possession with guns in the founding era, that means you can't do it. I mean, that's a caricature of even what Justice Thomas would say.
Right.
So I think she'll probably land on a Bruin sucks, but even under interest balancing, Hemani should win sort of approach. Kagan is the one that some people are speculating could still join Roberts and Alito. We'll see. Sotomayor seemed right on the same page as Justice Barrett. So at least given the questioning, and we always have to caution here that you have to be careful with questioning. Sometimes it can be misleading. So nothing's for certain until we get that ruling. But
and what just for the viewer, what Kostas is talking about is sometimes judges are out there and the questions really are they're telegraphing where they're coming from. Other times they're actually playing devil's advocate and they're just testing the other side, or maybe they still have doubts and they want to test one side of the theory or the other. Agreed?
Right. Yeah, no, that's exactly it. So, but that said, if we're going to go with if we're going to be making predictions, then based on that oral argument, with the understanding that oral argument can be misleading, I think we're gonna get a better result than we expect in this case. Now, I'm sure I'm going to have trouble. I'm going to have problems with the eventual analysis, especially given it's going to probably be a fractured analysis.
Yes.
But considering that this could have been a disaster.
It could have been an unadulterated disaster.
Yeah, so we should be happy with any sort of win here, even if it largely punts on other issues.
And I think you and I came away from it with Alito and Thomas, or not Thomas, Alito and Roberts are absolutely positively in the United States corner on this one.
Yeah, I think our current ATF chief counsel, Rob Leiter, said a few years ago at a panel, I found the video, that Justice Alito's guiding principle of constitutional philosophy is criminals should be locked up for a long, long time.
So a little bit of truth to that.
At the end of the day, Alito's with us on most Second Amendment issues, but he's just not okay with pot. So we're just going to have to live with that and hope we get to a hardware case soon where he'll be much more solid for us.
Well, that is a fantastic segue there, Kostas, because as we now have learned, our group of 5 cases that you, me, and Hannah Hill have been covering on WGLAM are set again for conference on March 20th. And just to get everyone up to speed, Kostas, Hannah, and myself have been doing these morning things. You guys should join us. Great way to start the work week. We've been carefully watching Duncan v. Bonta. We've been watching Gators Customs Gun versus State of Washington. We've been watching NAGR versus Lamont. We've been watching Viramontes v. Cook County. And we've been watching Grant v. Higgins. We are dealing with 3 assault weapon bans, 2 magazine bans. Any of them are a platform ban. We were not as shocked about the can getting kicked down the road this past Monday morning, though, were we?
We're talking about last week?
Yeah.
Yeah, no, I wasn't. At this point, the most likely outcome is continued relists unless something happens to change the equation. Now there's that DC ruling. Maybe that'll change things.
Well, that's there we go, right? So great minds think alike. And I want to pick your brain on this for a little bit, because this is the first time that a major appellate court anywhere in the nation has struck down a magazine ban. It doesn't create the circuit split that some said it did, but it's not a nothing burger. This is a big deal. How big of a deal you think it is, and what, if any, influence you think it could have on the Supreme Court's decision making?
Yeah, there's one of those weird things. It's DC's unique in that it's state kind of. It's not actually a state, but their state Supreme Court and their circuit court cover the same territory. It's the District of Columbia. So, although it's not a circuit split by the literal definition, in practice it is, because if this ruling stands, then the Hansen ruling is irrelevant because DC can't enforce its ban, So
well, and I think the important thing is that the Hansen ruling, which came out of the federal court in District of Columbia, was an interlocutory. They found
that's
it,
true
right?
too.
That was on a ruling on an injunction, whereas Benson, the case we're talking about here, is on the merits before a 3-judge panel.
Yeah, and there's a few things going for Benson, even though it's not technically a circuit court. It is a final judgment on the merits. And the U.S. has switched its position, so the federal DOJ now argues that magazines are protected arms. So it's just the district pushing this, and it's the highest court in D.C. now. And by the way, when there's this whole debate about circuit split or not, I should note that California, in its brief in response to the Duncan petitioners, didn't argue. They actually didn't say, oh, this isn't a circuit court, so there's no circuit split. What they argued was, okay, but this could be reversed en banc. So it's almost like they're conceding that if this stands and is not reversed en banc, then it is in practice a split that the Supreme Court needs to resolve.
California kind of backed themselves into a corner too, because their whole opposition to the petition was, this needs a little bit more time. No one's ever actually ruled to strike one of these down. And that argument has kind of gone out the window on California now.
Well, I mean, and they have multiple problems because their whole thing is, well, the DC Court of Appeals might reverse en banc, and frankly, maybe they will. We're about to find out because if they and I'll talk about this at the end on the craziest shit I've read all week. But if they actually stay the precedential value of this ruling, it's as good a sign as any that they're going to reverse it en banc. However, California kind of backed itself up here because if the Third Circuit ruling now goes the way we expect, then it cues up the Duncan, assuming Duncan isn't already denied by then, it cues up the Duncan petitioners to say, well, California said that we need a circuit split. You got the en banc court in the Third Circuit, so now we have our split, and they can't have anything to say about that. So we'll just have to see how quick the Third Circuit's going to be. I hope they're out soon, because my biggest worry is, the Supreme Court will just deny Duncan before.
And then we start all over with some new petitions next year, and away we go. What Kostas is talking about there is the case of Cheeseman v. Platkin, which was a challenge to New Jersey's assault weapon ban case, upheld at the trial court level, went to a 3-judge panel, but before they could hear it, a full en banc panel came in, took the case. We've had oral arguments. The oral arguments sounded like they went well. The oral arguments were also 6 months ago. And isn't it you that said that the Third Circuit is traditionally one of the quicker courts in issuing
I've only
rulings?
been following it the last few years, but they got range out pretty quick. We'll see. I mean, look, it's still on the table that they disappoint us. It sounded like oral arguments. Well, who knows? Maybe a couple of the Republicans are squishes and we lose. Anything's possible, sadly. But I think either way, I want the ruling out soon so we know. And then there's also the pending 7th Circuit ruling, but I'm not as optimistic.
That one. We might as well go outside and throw rocks at the moon on that one. But you would agree with me that if Cheeseman came out tomorrow and struck down the assault weapon ban in Jersey, Jersey has to appeal it. There's no way they're going to bend over and take it. Agreed?
Yeah, I know. Look, there's some theorizing that, New Jersey's going to strategically not seek cert. I don't think that's going to happen for 2 reasons. First of all, this is the hill they die on. This is about, magazines and assault weapons. It's their most marquee gun law. It's their biggest thing that they care about, even though it's kind of silly, but that is what they care about the most. Second of all, there isn't actually strategic value in New Jersey not appealing it, because the Miller ruling out of the 9th Circuit's around the corner. We're probably going to lose, so we'll just appeal that one and say, well, there's still a circuit split. So I don't see what New Jersey really gains by not appealing it when Miller's around the corner, and I'm sure there's a whole bunch of other assault weapons cases percolating up to final judgment as well around the country. So, like a couple of the ones, I think Grant v. Higgins, which is pending now, is interlocutory.
That's an interlocutory phase.
It'll go back down for final judgment. Maybe that'll take a couple years, but Miller is just pending a ruling from the 9th Circuit, and we know how it's going to go because Duncan is controlling. So
didn't Miller and Duncan get GVR'd on the same day?
I forget. I don't remember if Miller
was after Bruin. Wasn't Miller up on the up the SCOTUS and then he had GVR also?
Memory. I don't think it was, but I might just be wrong. Okay. I might be forgetting. But regardless, it's controlled by Duncan, so the panel will have to almost certainly rule against us. So the long and short of it is there's no strategic reason for New Jersey not to appeal. And I think they will, even if they think they're going to lose, just to make a point, because it's a political thing for them.
Had this question asked of me a lot when I was out in Illinois last week. Hello to everyone in Illinois. You guys were fantastic last week. Let's say that Cheeseman goes the way we hope it's going to go, and we really do have a circuit split. Is there any way the Supreme Court can still just avoid this issue at that point?
Yeah, they totally could. If there's I think Kavanaugh would be pretty humiliated if they did. See, here's the thing. If we get a circuit split and they still deny cert, that's pretty much a guarantee that Roberts and Barrett are not on our side. And let me tell you why.
It's a good point. Yeah, tell us.
In Snope, there were 3 votes to grant, and Kavanaugh concurred with denying it. And he basically said, we're going to deal with this soon. Now's not the time. Remember, it only takes 4 votes to grant cert.
Right, only 4. Don't need a majority of the bench to do that. That's right.
And we already know where Kavanaugh stands because he basically said in Snope in his concurrence, yeah, the Fourth Circuit seems full of shit. But so anyway, if we get a circuit split and they still deny cert, that means that Kavanaugh's looking over at Roberts and Barrett and they're telling him, nope, we're gonna join the liberals. So don't vote to grant this. And then Kavanaugh basically falls on the sword and denies cert just so we don't get bad precedent. So it would be a terrible sign if there's a circuit split and they deny cert because it basically means Roberts and Barrett are traitors. I mean,
it would be. I mean, because listen, we could start connecting the dots at that point. It'd be pretty easy. There would only be a couple of suspects at that point, wouldn't there?
Yeah. I mean, at that point, it would be all but certain that because otherwise, if they have at least one of the two, even if they have Roberts or Barrett, then it gets accepted. No reason not to grant cert. Yeah.
Right. Because we know Thomas and Alito are absolutely all in on this.
So is Gorsuch. Yeah.
And so is Gorsuch. Okay. Kavanaugh seemed like he was thinking about coming around, but not there yet.
Yeah, he basically said, well, the Fourth Circuit's clearly wrong. That's what he wrote in his opinion. Like, I don't see how this square, but, we'll get to this soon. It's just not time yet. We'll wait for percolation. Well, if you got your circuit split and you're still denying it, that tells us all we need to know about Roberts and Barrett at that point.
Yeah. Okay. Listen, I want to shift gears on you real quick. I read this amicus brief that I think you guys did over at SAF, Second Amendment Foundation. It's a matter of how Hall versus Sig Sauer. It's a P320 lawsuit. We don't even need to get into the merits of the lawsuit. Everyone kind of knows what's going on if you got a P320 suit. But at one point, there was this really crazy discovery demand made of SIG, and they got into a big old brouhaha over the discovery orders, and SAF jumped in on an amicus. But this is really scary what's happening here. Can you kind of explain to the viewer what happened in Hall and what the dangers of that is?
Yeah, sure. So this is just like one of the many of dozens of others of P320 lawsuits. And SAF, to be clear, as we state in the brief, takes no position on the merits of the lawsuit, whether the P320 is defective or not. That's for technical experts beyond what I'm capable of understanding. I love the P320 personally. Great gun to shoot. But anyway, so what happened here was that the plaintiffs demanded to know the identities and contact information of some dozens of people who had contacted SIG directly about the drop safe issue. This isn't even the current unintentional discharge.
And for those of you who don't know, the 320 had some drop safe issues, which I believe SIG offered free upgrades, free retrofits, whatever it took to get that problem fixed.
Yeah, it was called like a voluntary upgrade.
But then we transition into these allegations that the darn thing just goes off by itself.
Right. So anyway, they demanded to know these identities of customers who had contacted SIG. And this is a discovery dispute, and the SIG fought that, and the judge ordered them, no, you have to divulge it because not to bore everyone who isn't a lawyer, but in discovery, there's a pretty broad latitude. If it's even remotely relevant, you can usually get it. And there's only certain exceptions to that. So they filed a motion for reconsideration. They reached out to us and NRA and asked if we'd be interested in the issue, and we are, because regardless of what you feel about the P320, this isn't about the P320.
It's not. It's about right to privacy.
It is about the right to privacy. So
that's exactly what it is. Yeah.
There's this emerging area of Second Amendment law when it comes to privacy. So far, no federal court has confirmed that the Second Amendment grants any implications for privacy or is related to it, but some state courts have, and there's not very many rulings on the issue either way. So what our brief did is it went through the history of the Second Amendment and why, a right that was made about, resisting tyranny might actually care about privacy. And we talked about some court rulings like the Supreme Court of Michigan, I think it was, which decades ago actually said, yes, there is an expectation of privacy in gun ownership. So that's where we are now, and we'll have to see what the court rules, because the court did agree to reconsider it, which is rare. Not court district judges don't always do that.
It is rare.
He gave us leave to file our brief, so we have a judge here who's at least willing to hear us out. He's like, okay, make the argument. Let's see what it says. So I'm not saying we're going to win this. Again, it's a relatively undeveloped area of law, but we felt it's important for us, and to their credit, for Sig Sauer for fighting for gun owner privacy. And of course, they have their own reasons to oppose this besides high principles. I understand that, but it is still great that they're making this stand. Yeah.
And what I want everyone to understand is that privacy and firearm ownership is really critical, especially if you live in states like Kostas and I, where we are, in fact, behind enemy lines. Because gun ownership, and if you're in Oklahoma, Nebraska, whatever, man, we're like a badge of honor. But when you live in Southern California, like you do, or you live in the Puget Sound region of Washington State, we like to keep it more of a hush-hush activity. I think there's at least one instance of California doxing gun owners and claiming it was an accident, but not, tell us about that.
Yeah, that was the the CCW leak from 4 years ago now. Wow, time flies.
Yeah.
That was after Bruin. They put up some portal. It was supposed to be about data, like how many permits are issued, kind of like what New Jersey put in place. But it had it wasn't even a leak. They called it a leak, but there was just a download button on the website. You could just download all the underlying data, which doxed hundreds of thousands of people with CCW permits with their names and addresses, myself included, a bunch of federal judges, people who got permits because they were legitimately scared of somebody, some stalker or something. So it was crazy. But the point of bringing that up is just to say, like, look, there should be more privacy to this. And in some states, it's been destroyed. Like California, there is no privacy in gun ownership because they have a state registry of gun owners. Like I said, they doxed everybody. So in states where the fight can still be had, like Pennsylvania, we think it's important that it is.
Gun registries. I did a video today. It's about a new Senate bill, 3916. I actually think it's a reintroduced Senate bill. And what it really is a bill that says, hey, when we passed the Firearm Owners Protection Act of 1986 and said, don't make any gun registries, we really meant it. And here's another law that says, don't do it. The funny thing is it prevents the federal government from assisting in any of that. But you and I, because again, our states are like this, they're collecting so much data on state documents at the time of the transaction that the states they don't need the federal government's help. For example, in Washington State, back in the day when you could buy a semi-automatic rifle and or a handgun, which you still can, there's an extra form that an FFL fills out in Washington State, goes to the Washington State Department of Licensing, has all the buyer's information, has the make, model, the serial number, everything of the firearm. It goes to the state DOL. What do you think our state DOL does with it?
It's a future seizure list, obviously.
Right. Let me give you another example. So, I do criminal law. I get to do a lot less of it now than I used to. But back in the day when I was going full blast on it, you go in for a second appearance on a felony, and the person's been ordered to surrender firearms, and then the police say, we got 5 firearms. And you have a prosecutor walk in and go, hey, I got 8 firearms under your guy's name, and they drop the paper right in front of you, right? And it would be like, 1, 2, 3, 4, and 5 have all been reported as back in, but 6, 7, and 8 ain't here. Now, how do you have that kind of information if you don't have a gun registry?
No, they effectively do have a gun registry. That's what it's about. That's why they do this. California doesn't even hide it. I mean, it is what it is.
Well, if any senator out there is really bored tonight and watching Behind Enemy Lines, number 1, thank you very much. Number 2, go back and redraft 3916 and put some teeth in the damn thing. All right. Yeah. And tell the states to knock it off as well. Speaking of states, there's 3 states. 2 of them are doing one thing. One of them's doing another. But it's this, you and I spend all the time talking about how all states like yours and mine are constantly trying to eat away at the Second Amendment, test where that inner limit is of the Second Amendment, right? We got 3 states out there that are kind of trying to test the outer boundaries of the Second Amendment through automatic weapons. The first state is West Virginia. Now, this bill's not going anywhere this year. We've confirmed that, but it was Senate Bill 1071. Kentucky's kicking around one. It's House Bill 749. Now, Kostas, both of these, if they ever became legislation, would actually create an Office of Public Defense, different than the ones you and I are used to dealing with in the court system. The Office of Public Defense would actually accumulate automatic weapons and then serve as the FFL to transfer them to private citizens. And they are claiming that this is all under an exception of 922.02A, 922.02A, which does have exemptions to transfer these things to government agencies, things like that, typically for National Guard, law enforcement, SWAT, stuff like that. Question: how could any law like that survive a supremacy clause challenge?
It has multiple problems.
There is. Great idea, but man, we got to think this through a little bit more.
Creativity, so I don't want to like be discouraging.
Right. Totally.
And I want to be clear, the guys at GOA, the lawyers there are smart. They know what they're doing. So maybe I'm missing something. I've talked to some of them about it. And the basics. So let's start with the first thing. I think they're good. They're right when it comes to the transfer. So if West Virginia gives you a gun or sells you a gun, then yes, you cannot be prosecuted for the transfer because by the plain text of the statute, the government gave it to you. However, the statute prohibits possession. Yeah. And the GOA argument seems to be that, well, if the transfer is okay, then they can't get you on possession. But I don't read the statute like that. I think if you possess this gun, even if your transfer was okay, the federal government can still say, well, you can't possess it. So, you're not possessing this under the authority of the government, because as multiple courts have ruled, under the authority means working for the government. And just most recently, I think the 8th Circuit just had a ruling on this.
United States v. Went was the name of the case. And then there was one back from, I think it came out of the 10th Circuit back, might be 15 years ago, which was, wherever it's actually came out of Utah. I think it's Warner, United States versus Warner also.
Yeah. And there's another one in the 90s. So there's been a bunch of these. What I think, and frankly, what I've told them, I think I posted about this on Twitter too, which is what they should do if they want to give this a chance. And it's still a long shot in West Virginia because it's in the 4th Circuit. But what they should do is not just transfer it, but also say, this is about this. We're reconstituting our state militia. And so if you buy one of these guns, every 2 years, you have to show up for muster and you have to present your arms for inspection. And we're going to do a little one-day training. We're going to have a barbecue. We're going to do some shooting. It'll be a fun day. So it doesn't have
to be Kostas Moros out to lecture you for an hour.
Yeah. There you go. And so then you have a stronger argument that no, this isn't just the state transferring a machine gun. You do whatever you want with it. No, now you're part of the state militia. You can be called upon to serve if ever needed. And you have to meet every couple of years for muster, something like that. Then, we'd still lose because it's the 4th Circuit. But if I were a lawyer, I could make that argument with a straight face. I could go to court and say, no, this is under the authority of the state. They're members of the militia. This is historical. It's in line with what the Second Amendment is. It goes, back to the very roots of the founding era.
Very roots of it.
We'd still lose again. But right now, I don't feel like I could make the argument with a straight face. But if they adjusted the bill, I think I could. I got
to tell you that they both got pretty close, because if you look at their legislative findings, and you and I both know legislative findings are just made up out of thin air. Both parties do it. But they were talking about how, the citizens' duty is to protect not only themselves, but to protect government, to protect society, to protect us from tyranny, to protect us from foreign invaders, all of those things. So they put they kind of seemed like they were sprinkling up ready to go there, and then they just never actually put that into the statute.
It is in there. And I think what I'm saying is I think it has to be the focus of it. I think that's how you might have a chance in one of these cases. Now, the reason they won't want to do that is because that sounds like a lot of work. It goes from just being, I can have a machine gun to, now we got to do this training.
Well, yeah, now you got all this state mandated training. You're almost like a permit to purchase state. You got to come in for your mandatory training every 2 years.
And of course, our crowd understandably hates that and doesn't want registration, blah, blah, blah. But you know what? That's how, do you want a machine gun or not? Because I think that's how.
Well, it'd be difficult for West Virginia to do it, because two things that West Virginia lacks. One is a lot of money. And second is politicians who clearly don't understand economics. Because in West Virginia, when they don't have the money for it, they actually just don't spend it. Unlike your state, my state, that just, bottom line
and
is,
again, I want to be clear,
nature.
I like the creativity. I hope I'm wrong in that it works. It's two factors. Even if I'm wrong on my interpretation of the statute, the Fourth Circuit's going to say I'm right. They're going to say, they're going to adopt what I just said as,
let me ask you this. So like, let's say the state of Virginia, West Virginia or Kentucky passed this bill and it's got an enactment date. They're going to get sued probably by DOJ almost immediately.
Not necessarily. So what I think might happen, I forget which circuit Kentucky's in, and I haven't looked at the Kentucky version of the bill. So I'm only talking about
identical to West Virginia.
Identical. Okay. All right.
Yes.
What circuit is Kentucky in? I forget. Is it 11?
What's above the 5th there? Because they're going to be just above that. They're not.
Now I need to look at that. I need to pull up the circuit court map.
All right.
But anyway, to answer your question, I don't think the federal government necessarily needs to sue, because they would still have to go through the let me look at the map here, 6th Circuit. So a decent but not amazing circuit, if I remember right. But anyway, let's get back to the point. So let's say this happens, they would still have to do the transfer through the NFA, I'm pretty sure, because federal law is supreme. And so what would actually happen is the ATF would just deny the transfer. They just say,
deny the transfer.
Go F yourself. Like, we're not cute. Yeah. Good try, guys. But no, we're not. You're not under the authority of the government. And then GOA or the plaintiffs who were denied would have to bring a lawsuit against them.
They turn around and sue.
Yeah. So I think that's how it would play out, unless I'm not understanding something and West Virginia actually intends to give people these without going through the NFA, which would be, then you'd have a lawsuit, right?
Well, listen to the lawyers over at GOA. If any of you are checking this out and you want to hop on Washington Gun Law and have a conversation about it, I would neither Kostas and I are being critical at all. We love the creativity. We love the fact that you're testing the outer boundaries. We're actually trying to find a version that in our head is potentially workable here.
Yeah, I mean, I'd love to be wrong. Prove me wrong. Distribute machine guns. Awesome.
So Idaho's doing it differently. Senate Bill 1349 sets up the entire infrastructure, but it's a trigger statute. So there's one of 4 conditions precedent that would have to occur before they would actually enact the statute, or the statute would go into effect. And it basically is a finding of the unconstitutionality of 922.0, or the Attorney General choosing not to no longer enforce 922.0.
Yeah, that's nice, but I think that's kind of a little bit pandery. Like, you could always just do that later too. You don't need a trigger statute, but 922.0 is not going to be found unconstitutional because, and I'll tell you why. I had small hopes before, but when I read, was it Cargill, and Alito's like, yeah, Congress should just ban machine guns if they want this and I'm like, oh, so Alito's okay with banning machine guns, so therefore we're not going to win.
So we got officially 0 votes now if that ever gets up there.
Maybe we get Thomas on a good day, but that's it.
Yeah, we get an A vote, we lose 8-1. Cool. Awesome. Yeah. Listen, we're going to get to the questions in just a few minutes here, but I in kind of anticipation, there are 4 separate lawsuits kicking around challenging the NFA on the untaxed items. I believe SAF is in on at least 1, if not 2 of them.
2 or 3, I've lost count. Yeah.
and just to kind of set it up, the NFA was challenged shortly after it went into effect. All of the record keeping, all of the registration, everything that goes with being an NFA item was all held up in a case called Sutton-Zinski, all basically held up because it was through the government's taxing power and the records were necessary for tax keeping purposes. That, of course, argument is not nearly as persuasive anymore, and many of these are taking it on that way. What's your 2 cents on where these arguments are going, and have you seen anything outside of that box that's a little bit more creative in how to tackle this issue?
No, I think that argument is on point. At the end of the day, we think these are arms, and we think taxes on arms are unconstitutional. However, even assuming that taxes on arms are okay, which I don't want to assume, but let's say they are, with the tax gone now, all that you're left is with the registration scheme, whose entire justification now is gone. So basically what the federal government's trying to do is back up into this position that, oh, well, no, it's just a shall issue licensing scheme now, but that's not what it was ever intended as, right? So it's kind of ludicrous. That doesn't mean it won't win, but it's kind of ludicrous to say that. But just so you know, one of the reasons we have 2 or 3 of these cases in different circuits is, somebody might might suggest that we're trying to generate a circuit split here, you know, trying to brute force one with different circuits ruling on
whatever it takes, right?
Yeah, unfortunately, that is what it is. We've learned the lessons the hard way of what it takes for the Supreme Court to grant certain cases. So, you know, if we have to engineer circuit splits at SAF, that's what we'll do.
Yeah. There we go. Well, you ready to take some questions from our viewers?
Yeah. There's a couple of places on Twitter there. I don't know if you have your own separate list.
I got one up here right now. Now, if you want to pull one up also, I'm totally cool. But this is a really good cool. Yeah, this is a good question from Drew in Reno. So I'm guessing his name is Drew and he's in Reno. It's just a guess. Okay. Any thoughts on the judges that got picked for the Rody v. Bonta case? And I did see some discussion about that. Why don't you tell everyone what Rody v. Bonta is, and then tell us about the panel that's been selected?
Sure. So Rody v. Bonta is a case from my old colleagues. I've worked on it briefly about California's ammunition background check. And it challenges that check. So what that check is every time you want to buy ammo in California since 2019, you have to do it in person. You can't order online unless you have a FFL 03 license and a COE. So you go into the store, you pay for a background check each time. It used to be $1. Now it's $5 each time you buy ammo. And because they raised it, of course they did. And the big problem is that I forget, there's a standard check and a basic check, and I forget which one's which because the names sound so similar. But the cheaper check, because there's also a $19 background check system, but the $5 one has an erroneous denial rate of about 11%. So we did the math, and for every actual prohibited person it stopped from buying ammo, it erroneously stopped 412 law-abiding people from buying ammo. And what causes that is that it's based on where you last registered a gun. So if your current address is different than the one you registered the gun at, or if there is no record, then you'll get rejected, which is different than a denial.
Lovely. But there's no such thing as a gun registry.
Yeah, it doesn't actually explain any of this. So if you get denied or rejected, you might just think, oh, how did I become a prohibited person, and get scared off trying to buy ammo? And indeed, we got the stats from the state during discovery, or actually just Judge Benitez ordered it. And about 30 or 40% of people who failed to buy ammo in January of 2023 had not successfully done so by 6 months later. They just gave up. So anyway, we won the 3-judge panel. Because this is the Ninth Circuit, that doesn't mean anything, and it got en banked. And so now we had the en banc role in both this and Ukitake. They have different panels, but we got what I'd say is some people were over celebrating it this morning. I think it's not a lock, but it is. We've got a fighting chance here. So we've got it's a panel of 11. And so out of the 29 Ninth Circuit judges, because the Ninth Circuit is so big, they select 11, the chief judge plus 10. And so 5 are for sure against us based on history. I'd love to be proven wrong, but I think those 5 are solidly against us. There's 4 that are solidly on our side, I think, including Judge Van Dyke, Judge Bay, Judge Nelson, Collins. And then there's 2 what I'd call swing votes.
Okay.
Judge Miller.
And that's what it's going to come down to, isn't it? Those
pretty
2.
Much. We need both of them, though. We need both of them. So there's Judge Miller, who has no real 2-way track record. He was appointed by Trump, but I'm a little concerned because he agreed Teeter was moot when that came before the court. And so that's
Teeter v. Lopez out of Hawaii, right?
Yeah. That's when it was en banked after Hawaii had repealed the law. So that doesn't mean he's against us on the Second Amendment, but it's just a signal. Like, you know, I don't think he should have said it was moot. We'll see what happens. Then we have Judge Milan Smith, who, again, doesn't have a great history. He ruled against us on machine guns, which by itself is okay because a lot of conservatives aren't okay with it. But he also dissented on the Duarte panel, the 3-judge panel, and he called, that was the one about the nonviolent felon.
Yeah, 922 G1 challenge that I was actually watching that one before the Supreme Court because I believe the Ninth Circuit had ruled that was it an as-applied or a facial challenge isn't even possible to that.
Yeah, so he was on the dissent in the 3-judge panel, and he called in his dissent for an en banc, and they did en banc it and reverse Judge Van Dyke. So I'm not based on Miller and Judge Smith, I can't be hopeful that this is going to be a sure thing. However, we're in the fight. You know, when we got 5 against us, 4 for us, and 2 swing votes. that's better. In the Ninth Circuit, if it's not a certain loss, you're doing pretty well.
That's right.
So
as good
so,
as the
so we'll
absence of bad equals good in the Ninth Circuit.
And then Ukitake, I think, is even more. So Ukitake is 6-5 against us. However, one of the Democrats is Judge Owens, who ruled for us in Nguyen in the 1-in-30 rule. So that one's a total toss-up. If Judge Owens sides with Ukitake, then that one might be the better panel than Rhodey, frankly. So we'll have to see how it goes. But
what would the gun grabbers do if all of a sudden the Ninth Circuit started striking down gun laws? They would crap themselves.
Yeah, I guess it's okay, Rob Bonta. You can appeal to the Supreme Court, please.
Yeah, take it. Do it. Do it. We dare you. Hey, real quick, while you're looking up another question, this one comes in from Ray White, and he's talking about in Cheeseman, New Jersey reframed dangerous and unusual as unusually dangerous, sidestepping common use. Aaron Murphy replied with unusually dangerous as to what? Was it a mistake to accept that framing? I'm not sure she really accepted that framing. I think he's talking about the arguments she did in the Cheeseman case, which I listened to live. I think you did too.
Yeah, it was a while ago now, but yeah, no, she absolutely didn't concede that, right. That's the correct framing. What she's saying is the problem with this unusually dangerous or unusual thing is every gun is dangerous. Relative to pretty much any other weapon in existence, relative to a knife, a spear, a rock, whatever else, a gun is dangerous. So if you're just going to say unusually dangerous, then every gun should be banned because, it
injects balancing back into it because the judge gets to determine what's unusual and what's not.
Right. Whereas, the reason dangerous and unusual makes sense is because it's not enough to be either one. If you're just dangerous, but you're not unusual, well, that's every gun, like every handgun ever, for example, is dangerous, but it's not unusual. Or if you're unusual, but you're not really dangerous, like nunchucks, they're a little bit unusual other than in dojos, but they're not really lethal. I guess you could really bash somebody's head open, but they're not.
Bruce Lee could. Bruce Lee was real good. Yeah,
exactly. So I think dangerous, even if when it was phrased dangerous or unusual, the only thing it could have possibly meant was both, so it's just a stupid little cute argument they're trying to make that if the Supreme Court actually ever took a hardware case, which
they knock all this crap off.
No, they would never
in common use for self-defense. That's not the rule of law.
No, it isn't. And I think that actually came up at one of the arguments.
It came up in Benson. The court, Benson shot that. That's why everyone should actually read that opinion, because it takes every argument that Kostas and I have been reading for years now, systematically takes it apart. The court, I think, wanted to uphold the ban, but that simple, plain English kept getting in the way.
Yeah, Benson is a ruling that really exposes the bad faith of the other courts, because all these other courts, like, they bend over backwards. They talk about Bowie knives. They say what is or isn't an arm and all this nonsense. Benson's a very straightforward ruling that anybody who's not even a lawyer can just read and understand.
Yeah. You have a question over there? Did you grab one?
Yeah, let me get back to the page because I was.
And while Kostas is doing that, when he pulls it up, let me just fill in a little time here. What I want everyone to understand, and why the common use doctrine is so critical, is because the common use doctrine actually gives the Second Amendment its true intent. And the true intent is that the American people get to decide how they're going to defend their lives, not government. And the common use doctrine ensures that the American people are the decision maker.
Yeah, no, absolutely. Okay, I have a couple here.
All right, let's hear it.
What is the holdup with the California 11% excise tax on guns and ammo? So that the holdup there, guys, is that the Tax Injunction Act by Congress made us sue in state court rather than federal court. And because California state courts, not only are they against us, we're probably going to have to lose our way up and then hope the Supreme Court cares, but they're also exceedingly slow. So California filed its demur, which is the state equivalent of a motion to dismiss, several months ago, and it's not going to be heard till like July or something.
Oh, nice.
So we'll get a ruling sometime after July, probably by the end of the year, maybe, and then we'll lose, and then we'll have to appeal, and then we'll lose, and then this California Supreme Court will deny, and then we'll have to appeal to the Supreme Court and say, pretty please, do you think the founders would have been okay with an 11% tax? And they'll probably deny cert, but not to be too pessimistic, but just how it's been going.
Yeah, but we weren't too cool with a 1% tax on tea. So Gonna point
it's
that
such
out.
nonsense. Not to be overly pessimistic. I really do hope that.
Well, no, but that's sometimes what you got to do is you got to lose your way up.
Yeah.
Right.
No,
and when you're challenging in California and to some degree in Washington State, because we're both in the Ninth Circuit, we literally do have to lose our way up until we finally get a fair shot.
And the California state court system makes the Ninth Circuit look like the Eighth Circuit. I swear, it's so bad. My gosh. I hope they prove me wrong. Look, I hope we get some good faith judges who say, no, it's ridiculous to tax a constitutional right. What are you talking about? But I'm not going to hold my breath. I really hope that they restore some faith in the state judiciary. But what we need is a federal case on taxes. But Pittman Robertson is a little too popular for that to happen.
Right. Yeah. It's a good question though.
Yeah, it is. It's an excellent question because I get frustrated with the same thing. Brian LaFonte. Brian, I don't know how to pronounce your last name, but
LaFonte. It's LaFonte tonight.
Yeah. So what do each of you consider the top 5 most important 2A issues in order of importance? And he says, for example, mine would be 1, the hardware cases, so assault weapons, mag bans; 2, nationwide reciprocity; 3, homemade firearm restrictions bans; 4, excessive fees; and 5 is gun-free zones. My list would be similar. I would have hardware cases and reciprocity as a tie. Those are my 2. Like if I could just pick 2 issues to win on, I want reciprocity or nationwide constitutional carry. Either one is fine. I prefer constitutional carry, but I'll take reciprocity. Hardware cases, of course, are very important. I would put sensitive places at number 2 behind that tie, because I think if when they've restricted all these places you can carry, they've basically nullified the right to carry. So that's number 2 for me. Excessive fees would be number 3, because that's another thing we deal with a lot. I have a California bias. I admit it. I'm here. So the
but listen, you guys are the trendsetters when it comes to gun control. I mean, California is, unfortunately, California is on the cutting edge of gun control. So you guys will have crap that we won't have in Washington for a few years.
Yeah, it's coming. Don't worry.
I know that. Yes, I'm completely aware of that.
As Virginia's finding out. But I probably undervalue, and this is my own fault, but homemade firearm restrictions, because it's just never something I've gotten into. It's important, and the history is clear that Americans have always had the right to make their own firearms. It's just, it's admittedly a little bit more academic than the much more pressing issues of the hardware bans, the excessive fees, the lack of reciprocity. So those are more pressing to me. But yes, I agree that homemade firearms is an important issue. I also think registration, it's not on his list, but it's a big one, because it kind of ties into fees. But like, for example, in New York City, you have to register each individual gun you own, and you have to separate them out by 90 days. It's crazy. So that's also a huge burden on the right.
Well, listen, I'm not going to give you my list, but I'm going to tell you the one that hasn't been mentioned yet, and it is a big bugaboo for Washington gun law, and that's pre-purchase licensing.
Yeah, man. Yeah,
because I think that anytime you have to go get a permission slip from a government before you can actually go access a right, that is exercise a right, it is no longer a right. It's a privilege at this point. So I think the FOID card in Illinois and any of these other pre-purchasing, we're going to one in May of next year, so is Oregon. Absolutely. And if you take a look at how these FOID cards are abused in Illinois and how quickly they'll yank them and how impossible it is to get them back, you can lose your FOID card for getting charged with a crime that, even if you got convicted of, wasn't a forfeitable offense.
Right.
So
yeah, it's crazy.
So to me, pre-purchasing licensing and the platform bans are 1A, 1B, because I believe that those are the 2 biggest infringements into the Second Amendment. I do agree that the sensitive places is really important, because when that pesky little thing called the Constitution says you got to allow people to arm themselves, you see in these states turn their states into big, gigantic gun-free zones where there's nowhere where they can exercise that right.
Right. Another person asks, do you think the Valor Ridge /GOA lawsuit has a good chance to make a big impact? Is that the new Illinois non-resident carry one?
Yes.
Yeah. I don't think that. So not to disappoint you, but if I read that, I skimmed that complaint last night, and I don't think it's actually asking for reciprocity, because this question asks, I think their efforts show how burdensome the lack of reciprocity is. I think this is another one like what we did in California and like in New York, where they're just asking for Illinois to actually let all non-residents apply. Because right now, Illinois is one of those states with weird rules where only certain people can get a non-resident permit, but not others. I forget the exact standard they have. I know in Oregon, it's only border state residents can get one. So California,
yeah, it's just asinine. Speaking of reciprocity, did you read the response brief in Gardner v. Maryland yet?
Yeah, it was surprisingly weak, especially
amazing for asking for 3 extensions.
Yeah,
three different extensions, and then you throw that, and they don't even want to argue the issue on the merits. It's all like, oh, there's this deficiency with the case, and there's this procedural irregularity, and this just isn't a good vehicle, and this argument was waived, and they literally never get into the merits at all on that thing.
Yeah, it's a frustrating one to read because it is very weak and unpersuasive. However, at the end of the day, they argue, well, there's no circuit split, and that might just be enough to kill it, because this is the Supreme Court and they like to dodge stuff. They talk about, because our amicus brief made a big deal about the traveler's exceptions, which is the most relevant historical history on this. And
almost directly on point.
Yeah, and basically they only spent a page on it dismissively at the end. I'm glad they mentioned our brief though, because that makes the Supreme Court more likely to read it, So hopefully, and
yeah, it's a big day when in an opinion an amicus brief is actually quoted. You've done something with an amicus brief when the opinion's actually referring.
Yeah, and I've gotten there a couple times, and it's really fun when they do take something from your brief, because a lot of times they don't. That's right. The thing about amicus briefs is courts can just ignore them as inconvenient. If they don't want to address an amicus brief, they don't have to, because it's not.
Well, what I've always enjoyed with the way SAF has done it, and Barry Arrington, when he was with NAGR, was really good at this too, which is it's not a ditto brief. Right? Sometimes you read these amicus briefs and it's just like, I think I've read this brief already. But instead you find like one little angle. Maybe it's an angle that wasn't explored real well in the actual petition, or maybe it's an angle that wasn't explored at all, and you bring that up. Those are the good amicus briefs, when you're bringing something else to the table other than a ditto.
Right.
Let me ask this one of you here. Any idea when the Seventh Circuit's going to rule on the Illinois case? I believe they're referring to Harrell v. Raoul. I think Barnett v. Raoul's attached to that also.
I don't. This one's kind of I have no idea. But I will say that because 2 of the 3 panel on there had previously ruled on the preliminary injunction, that's Judge Easterbrook and Judge, I forget his name, the dissenter who was on our side.
I'm not going to be able to help you on this one. Yeah.
But anyway, Judge Wood, who was against this, got replaced by Judge St. Eve. And I'm not optimistic about Judge St. Eve. However, the longer this takes, the more I start to get a little tiny bit of optimism that maybe she's thinking about something. Because if she just agreed with the last one, it should be a pretty straightforward ruling. Easterbrook's on the same panel, just reissue the last ruling basically with some adjustments. We'll see though. I could be totally wrong to be hopeful. And it might go as I expect, which is we'll lose this. I think based on oral arguments, Judge St. Eve seemed like she might be with us on the question of what is an arm, but maybe not on the history. She might say there is.
This was a 3-judge panel, wasn't it?
Yeah. So
okay. So even if PICA was struck down by the 3-judge panel, which would be totally awesome, they will appeal to the full en banc panel instantly, and the full en banc panel will take it. Don't you believe so?
I'm not sure. The different circuits vary in how often they do en banc. Like I think one of them, the First or Second Circuit, never does en bancs.
Okay.
I don't remember what the Seventh Circuit's practice is. I will say that if St. Eve's on our side, if she surprises me and is on our side, that probably shifts the en banc. I would have to go back and look at what the tally is in the Seventh Circuit, but that might make an en banc not a sure thing for the anti-gunners. Well, I shouldn't be speaking out of turn. I would need to go look at the numbers.
Yeah, well, but do we really think that Illinois would take that line down? I mean, there's no way. The way they shoved that PICA Act down their throat, they're not going to just allow it to die.
Oh no, they'll appeal. They'll try for en banc. They'll try for Supreme Court. They'll absolutely appeal that.
Yeah. All right, you have one.
Yeah, given the recent SCOTUS case of U.S. v. Skirmetti, de facto holding transgender people enjoy no 14th Amendment protection. That's not what Skirmetti held, but anyway, they'd be constitutionally disarmed under Bruin's text, history, and tradition test by categorizing them as mentally defective. Do you think the founders would have permitted them to be armed? So what the founders would consider a disarmable group has changed because we've amended the Constitution. So. That's right. Just like the founders would say, well, you can disarm slaves, right? Well, now we don't
Well,
have
yeah, because they did. Because
yeah.
they did. That's why the Catholics and the Irish and the Loyalists and all of them.
Yeah, well, Loyalists you probably could disarm, and they
that one I don't have as big a beef with. I get that one.
The Catholic one, actually, Madison opposed that, so they got rid of
Catholic. That one still stings a little bit, but that's all right.
But they got rid of that. But the point is, what the courts have concluded is that, based on Rahimi, is that dangerous people can be disarmed. I don't think you can say, whatever your feelings about transgender people, I don't think you can say that they as a group are more dangerous than others, than other groups you could identify, like, and because it is, I'm getting into dangerous territory here, but it is a self-selecting group.
Let me bail you out here a little bit, because this is a touchy issue. But categorical bans in general are very problematic for gun owners, because the political winds shift and change. The leadership shifts and changes, and giving government the ability to just, with a broad brush, disarm a whole group of people just because they think a couple of them might be dangerous is probably not what the founding fathers intended.
Yeah, I mean, and even if the founding fathers would disarm certain groups, again, the law has changed, the Constitution has changed, because we've amended it. That's the power they gave us when they adopted it. And so dangerous people is the standard now. And I don't think, again, maybe some would argue, oh, hey, transgender people as a group are dangerous. I would caution that that's a very dangerous path to go down.
I agree.
When we might have a President Newsom in 2029. So
I agree. And I understand people's concern, and I understand the numbers. I have done the research. I have resisted doing a video on it for a couple of different reasons. And one is I just don't like the categorical bans. I just don't like.
And it's not even that. It's also, look, you don't have to agree. So I know people have strong feelings. I have my own feelings about it. You don't have to agree when someone who's a biological male says I'm a woman. You don't have to agree that they're a woman. What you do have to agree with, I think, is that person, whatever they may say they are, whatever gender, they do have the natural right to defend themselves against a violent attack.
Yes, the Second Amendment is for everybody.
Yeah, they still have dignity as a human being, even if you disagree with what kind of human being they say they are, right? So what gender they are, but they still have that worth. And I know it's scary times because some individuals in this group have carried out, violent attacks, but you know what? So have a lot of groups. There's been a lot of white male mass shooters. There's been black.
There's been a lot of white male mass shooters. There's been an awful lot of them.
So maybe let's not go down this path. But anyway,
it's a good question. It's a good question, and it is a touchy issue. And unfortunately, it seems like every few weeks it gets shoved back into the forefront of the news again.
Because there are these shootings that happen, frankly, involving trans people. I'm not going to hide that this happens. It does. Right. It does. But
and it happens at an alarming rate when you consider the size of the population compared to what's happening here.
If you reframe the question and you think particular people are dangerous, and the state wants to say this person is dangerous because they posted this crazy I saw one video or one picture that was going around of this transgender individual who had posted video or pictures of themselves putting a gun in their friend's mouth and stuff. And I'm like, well, that's evidence that you're dangerous. At that point, maybe at that point you can make a different argument about that person.
Well, because we're basing it on an objective criteria that we can attach to that one individual.
Exactly. So that's different than a class-based ban. Anyway, moving on. What can we do to help national reciprocity legislation to move forward? Look,
get 60 senators.
Yeah, there's two. If you're talking about short term, I'm going to be real with you. There's nothing you can do. Short term, there's nothing you can do. And I don't like when some other activists will say, call your senator. We passed reciprocity in the House. Now you need to call your senator. It's false hope. You cannot win this unless there is massive opinion change in the Democratic caucus, or if there's ever 60 votes in the Senate, or if we ever kill the filibuster. I guess more likely.
Which that could come back and haunt us. So, and I get it. There's all that talk right now because the SAVE Act, and I'm a big believer in it. It's a very important piece of legislation. But why have we only had one federal assault weapon ban in the history of the United States? Oh, because of the filibuster. That's why.
I was actually advocating after the last election for killing the filibuster because Democrats said they would do it. But now we're so late in the game. The midterms are right around the corner. Like, no, it's too late now. We should have done
if they were going to kill it, they should have done it like the day
right
after he was sworn in.
So how this might play out is Democrats might come back into power, whether it's 2029, 2033, whenever it is, and they'll kill it. But and that'll suck for a few years, but then the next time Republicans are in power, well, all bets are off. Now we can pass what we want because you guys killed it. So it's always cyclical in politics.
But I'm telling you, America, if we don't have that filibuster, if they ever have a majority in both the Senate and the House, you are getting a national assault weapon ban shoved down your throat so hard. Hard. It's going to happen. Magazine ban. God only knows what they'll do. And then we'll be waiting for the Supreme Court to bail us out. And we all know how quickly that takes. Ask everyone who's working on Duncan for what, 9 years now? Yeah.
So my point is you should, what you could do long-term though, and maybe this will happen on its own long-term as more and more people get carry permits. You know, I'm hearing New Jersey has like 90,000 or something, and California is finally now places like LA are starting to speed up in their issuance. As this becomes more normalized in blue states, you could start to see a bit of a cultural change where there is more of an opening for reciprocity. Maybe you get a couple more. I'm not saying Fetterman is good on reciprocity, but what I'm saying is more senators like that who are more open to more ideas, and maybe you can claw your way to 60. But right now, that's a decade or two away. I don't think it's happening yet, and I would just be wary because what I don't like to see sometimes is when sometimes our allies in this field, pro-gun organizations, hype people up with unrealistic expectations, like the idea. Big time. And people get disappointed. It's like, no, you shouldn't be disappointed because we are moving the ball forward. I myself get disappointed with the Supreme Court on the hardware case front. When we're talking about the overall culture here, I know it's easy to forget, especially when you have situations like what's happening in Virginia right now, where it feels like we're losing ground. But long term, compared to where we were 50 years ago, we've made a ton of progress, man.
I agree. I agree. I think the Second Amendment is healthy as it's been in 40 or 50 years right now.
For sure. And that doesn't mean the fights don't matter, and that doesn't mean we still do need to win the battles. But what can you do to
in some ways you see the attacks have been heating up because I think the other side realizes like, boy, it's kind of fortifying itself again.
Yeah, that's why, why do you think in Virginia, Spanberger and the Democrats didn't run on gun control? That was
never said a word about it. They also ran on affordability and then started dropping taxes.
They're raising all the taxes. But what happened was every town, and Michael Bloomberg gave them millions of dollars. So now they're doing their bidding. But the energy is not on the side of gun control right now. It might be on the side of Democrats because midterms are always tough for the party in power. That's just how it goes. But what you can do for reciprocity, I'd say, is talk to your friends, if you have any on the left, and take them out shooting, make them understand how BS it is that you have to get a permit in all these other states just to exercise a right. Change hearts and minds. It's not a satisfying answer, but that's what it is.
I know. Didn't you recently do a post about a married couple that had actually done what it took to get licensed in as many states as they possibly could? What was the cost on that though for them to do it?
So it's a bit of a mix because I think after a while the wife dropped off of some of them because
she said to hell with it. She's like, I can't afford this anymore.
46. They got enough permits that would let them carry in 46 states. So they don't actually have 46 permits because a lot of states are constitutional.
Arizona get you a whole bunch, right?
Right. So they got as many permits as they need to get as many states as possible, which is 46 states plus DC. The last 4 states they can't currently get permits in. That's like Illinois and Oregon and a couple that have and Hawaii, which Alan Beck is now suing in Hawaii over their ban.
Well, that's what Alan Beck does. Is he makes life for the Hawaii government miserable, and he does an excellent job at it.
Yeah, absolutely. So, but to get those 46 states, it costs them $12,800, so about $13,000, and that doesn't count all the renewal fees, all the training courses. Because remember, if you do one 16-hour training course in New York, that's not going to work in California. So they have to do the training courses. They have to, it's a whole hassle. So we referenced part 1 of their video when they were up to about $7,000 or $8,000 in our amicus brief for Gardner. And I did send the counsel for Miss Gardner this updated video, which they posted yesterday or 2 days ago.
Cool.
And maybe he'll reference in the reply, maybe not. I know he has a page limit, but I'm hoping, it isn't just Justice Thomas asking for a reply in Gardner, and we actually, get some real movement.
Dude, Kostas, I got to tell you though, man, I am so happy the way that, because, I found that case on accident, right? And then I said something, and you grabbed the football and you ran with it, and you got an amicus brief. Then you talked in a bunch of other organizations, and we actually turned this into something. I mean, Miss Gardner's got a puncher's chance on this thing now.
Yeah, I mean, the amicus briefs. Unfortunately, we didn't quite get the grand prize, which would have been a DOJ amicus brief, but we got everything short of that. We got a bunch of state AGs, we got some U.S. senators, so it has attention. Whether it's up to the Supreme Court now whether they're going to do anything about it, but we left it out.
Got the most compelling set of facts too. It's like a law school problem.
I mean,
right?
We even say they could even, if they don't want to grant it now because they want to develop it more, they should at least remand it to the state Supreme Court and say, no, do the historical analysis, which you didn't do, like at least give, and that would be something. So I hope they at least do that. All right. Aside from Lawrence Van Dyke out of the ninth, who else deserves a SCOTUS nomination?
Oh, that's a good
Judge
question.
Van Dyke only. Judge Van Dyke or bust. No, just kidding.
He definitely is number one on the 2A list. I don't think there's any question about that.
And look, Judge Van Dyke, not to drift too far out of our field, he had a very awesome but contentious dissent in a case last week dealing with the transgender issue.
He did.
And I think it was great. It brought attention to the issue. But however, whether it helps him in the politics of confirmation, I don't know. I won't pretend to know what these old boring ass senators want. They might be obsessed with decorum. I'm not going to pretend to understand the politics of confirmation. What I will say is if we had our way, Judge Van Dyke should be on the Supreme Court. There are other excellent options, though, that would not be disappointing to me. In the Ninth Circuit, Judge Bumate, Judge Lee, also great options. Really like them both. Judge Oldham, I don't know if I'm pronouncing that right, but Judge Oldham I think it's the Fifth Circuit.
Well, the Fifth Circuit's got a couple of good justices down there.
Yeah, absolutely. Absolutely. So there's a couple things that go into it. You need to have the right credentials, of course, in your case history, but you also need to be the right age. Because I see some people saying a couple times, put Judge Benitez on the Supreme Court. I'm like, look, I love Judge Benitez, but the guy's in his 70s, and we don't want a 5-year rental here. No. We want, we want a long-term.
Supreme Court justices are now all like in their later 40s.
Yeah, later 40s, early 50s. So Judge Van Dyke, for example, is 53, just right in the right age.
Perfect, right in the wheelhouse.
Yeah, I think Judge RBG got appointed when she was like 60, and that's the older end of it that you usually see.
Let me ask you this one here. I got a good question here, and this is one I've actually had to ask before. So the 10th Circuit ruled that New Mexico's 7-day wait was unconstitutional and sent it back down. The district court then put a preliminary injunction on that. Yet we also have another ruling out of Colorado that actually went the other way, and they're both in the same 10th Circuit. What's going on there? What happens in that situation?
I would have to look into it, because if the 10th Circuit ruled that the waiting period's unconstitutional, then how would a district judge say otherwise? Isn't the 10th Circuit controlling?
Yeah, well, they would be. Yes.
I wonder if there's some distinction in there that I need to go take a look at this case if I haven't, because that sounds odd to me that they could just ignore I realize it's a preliminary injunction ruling, it sounds like, so maybe that he could say, well, it was just a preliminary look, maybe, but usually unless there's some differentiator, they're going to follow the controlling. Though judges doing whatever they want in this day and age doesn't seem doesn't seem to matter anymore. Yeah. Even the First Circuit had to overturn a judge today, which you never see. So
real quick. Hey, Stephen R115, did I enjoy West Central Illinois? I enjoyed all of Illinois, but you guys, next time I'm out there, knock off all the freaking tornadoes. Okay, that was. I'm a Seattle kid, man. We don't have tornadoes up here. We don't have anything except earthquakes, and that was scary as shit, man. That was scary.
It's not fun. I have family in Ohio. When I was a kid, we had
so you know the drill.
Why hasn't any California official been personally sued for civil rights violations over CCW delays? In my simple mind, a public servant who blocks a civil right should be liable. Thanks for the good work you do. Two things. When it's a state official, first of all, there's qualified immunity. But when it's a state official, qualified immunity you can get around if it's a clearly established right that they're violating.
And they intentionally violate it. Yes.
Right. But the bigger issue for a state official is the 11th Amendment. You actually cannot sue a state official for damages in federal court under because of the 11th Amendment. You can sue to enjoin them. You can tell them stop doing something, or you have to do something, but you can't actually get damages because of the 11th Amendment. So
have you ever taken a look at 18 United States Code 241 and 242?
They're not ringing a bell. What are those?
Yeah. So you know how we always talk about 1983 claims and you can sue them civilly. Well, 241 and 242 actually allows the Attorney General to file criminal charges for willful violation of constitutional rights.
Right. And maybe that's something the DOJ should explore. But again, they would still run into the 11th Amendment.
They would run into the 11th Circuit, and it is a boy. That would be a crossing a Rubicon there, wouldn't it?
I mean, it could happen against local officials. Certain local officials which are not state. So, for example, if your local PD has an excessive permit fee structure, let's say, even though they know that's not, let's say some courts have ruled that unconstitutional, then you could do that, because they're not part of the, well, actually, the case law in California gets complicated on who is and isn't a state official. But my point is, if they're not a state official, you could get somewhere with that. I have another one here. Do you think Thomas and Alito should retire before the midterm so that President Trump can nominate their replacement, since there's a good chance that GOP might lose the Senate? Yes, and even if they don't lose the Senate, yes. I love both Alito and Thomas especially, but the reality is Alito's in his mid-70s, Thomas is in his late 70s. They just saw what happened with RBG, who held on too long. Yep. Do they really want that to be their legacy? It sucks to say. I would love for them to both live to be 100 years old and have 20 more years, healthy years on the court. But the reality is what it is. I think they should retire this summer. And I think both of them should be replaced. Because remember, even if the GOP doesn't lose, the midterms are going to be probably tough. Even if the GOP doesn't lose the Senate, they could lose a couple seats, and then you're down to 51 votes, and you got to run everything by Senator Murkowski. Do you think you're going to get a great Supreme Court appointment if Senator Murkowski gets to pick who she wants?
That's a real small R next to her name.
Yeah, exactly. I mean, I prefer, and the frustrating thing with her is she's not like Collins. I can live with because it's Maine, so the alternative is a Democrat.
Alaska, but in Alaska.
Come on, like that's just a total freebie we're giving up there, where we could have
because Alaska is red as Hawaii is blue.
Absolutely. So there's no reason we need such a squish there. Collins is like the mansion of the Republicans. We'll take her because everything we can get from Maine is a gift.
Mansion of the Republicans. That's a good analogy.
Well, it's exactly right, because just like he was uniquely.
I like Joe Manchin. At least the dude was attached to reality.
Yeah, he was uniquely able as a Democrat to win in a deep red state. As soon as he retired, Republicans took that seat immediately. That's the same thing that would happen with Collins. Hate to break it to you, but Collins is a gift, but Murkowski is just a frustration. Anyway. So yeah, I absolutely think they should do what I think would be the responsible thing and retire. But at the end of the day, it's their choice, and we can't force them to do anything. So if they want to stick around, I'm sure they'll keep issuing great rulings. I would hate, God forbid, if something happened like what happened with Justice Scalia. Or what happened with Justice Scalia? We got lucky because Trump won that election.
It's all about timing. It's all about timing.
So God forbid,
well, and of course, there's been this rumor that Alito may have a book coming out in the fall, and we don't think he would stay on the bench if he's going to have a biography.
Well, maybe, but I think didn't Judge Barrett just write a book? Justice Barrett. I don't know if writing a book means they're retiring. I hope it does. But yeah,
that's a good question. I got one, FTN 5546, Duncan v. Bonta, GVR again, or SCOTUS finally says we meant what we said in Heller and Bruin. The thing with Duncan and v. Bonta is there is no case from which it can be GVR'd back down on.
Yeah, I mean, I guess they could.
Hemani, Wolford, neither of them are going to get us there.
Yeah, I guess they could just do a punt GVR where they say read Hemani and Wolford, even though nothing about those would change if they just want to buy more time. What I've suggested to the Supreme Court, even though it's unorthodox, what I said in our brief was just hold it over the summer. Who cares if it's unusual? You're the Supreme Court. Nobody's going to correct you. If you don't there's nowhere to appeal to beyond that. So you get to make the call. Grant it, or if you don't want to grant it for whatever reason, just hold it forever. Just do not let that mandate issue, because then we're screwed if they let the mandate issue. I have one person. Oh, it's back to where did it go here? Brian LaFont replied, or he says on their live stream, which we're doing now. Kostas and Bill said Alito would obviously not strike down 922-0. Cargill suggested he would not do so on 2A grounds. But don't forget, he said that it was unconstitutional on Commerce Clause grounds in US v. Rybar when he was on the Third Circuit. Fair.
Well, first of all, we got a viewer who's doing his homework, so
yeah,
let's give it up for that. That's solid.
It's a fair point. My philosophy, and it might be wrong on Alito, my philosophy has always been that when it comes to gun cases, if they're not going to give us a win on Second Amendment grounds, then they're not going to give us a win on Commerce Clause or some other grounds. You know, I could be wrong about Alito because he actually is very principled, and maybe he would say, I don't have a Second Amendment issue with this, but I have a Commerce Clause issue with this. But even so, we still have the problem where, okay, we got Alito and maybe Thomas. Who else we got? You know, maybe we get Gorsuch. Yeah. We're definitely not getting Roberts and Barrett, and probably not Kavanaugh, and definitely none of the liberals. So I think the machine gun issue for this generation is still a loser. That could change in the future.
I think that we got some. I think there's lower hanging fruit out there right now.
Yeah. I mean, let's get our regular
not poo-pooing it at all. But I just like every American to be able to go in and buy a semi-automatic rifle that accepts a detachable magazine. That's
and then
right,
we're gonna have other battles. Yeah. We're gonna have other battles too. Every state, let's say we win a hardware case, all the blue states are gonna adopt the Colorado law. You know, we're all gonna have
licensing, and it's a $5,000 license to be able to own, and you can keep it, but you got to register it, and they'll just they'll never roll over and die on it.
Machine guns are very downstream right now. I think we need cultural change. Like Kerry, look, the Second Amendment said that expressly says there's a right to bear arms, and yet it took until 2022 for a court to confirm that. And the Supreme Court only did that, by the way, after the battle had already been won. There was only like a few states like California, New York, and the usual suspects who still didn't have shall issue. So the Supreme Court often follows cultural change. It doesn't lead cultural change. And so at the end of the day, we can't just keep, I'm a litigator. Of course, I want the Supreme Court to take cases, but we can't just keep counting on the Supreme Court to bail us out. We have to go out and actively change the culture, win at the state level, and the Supreme Court will come.
And what Kostas just said there, win at the state level. We are so frequently, everyone's looking up thinking that their rights are going to get taken from the top down. Your rights are going to get taken from you from the bottom up. Mm-hmm. So you got to pay attention even to these school board elections. You sit there and you open up, you get on the news one day, you're like, all these nut jobs got elected to the school board. Wow, what's going on here? Well, the problem is 4 years later, those same nut jobs are all getting elected to the state House of Representatives. And now they're writing gun laws, and they're writing tax laws, and they're writing all sorts of other things that doesn't see the world your way. So it's a good point. Hey, that was fun, man. That was our first ever edition of Behind Enemy Lines Q&A. I think we handled it pretty well, Kostas.
Yeah, I think we did well. It was a lot of fun.
It was good questions. We got a lot of good questions.
Yeah,
I had a few comments down here too, but weren't to share those. But hey, let's move on to the next thing, because you already had something, which is the craziest shit I read all month. It's craziest shit you read all month.
So yeah, DC, after it lost its magazine case in Benson,
yes.
It's now asking not just for a stay, which asking for a stay is normal, but a stay only affects the plaintiffs before it, and it doesn't affect the precedential value of the ruling. They're asking for the DC Court of Appeals to stay the precedential value of the ruling until after they can decide en banc. As Benson's response pointed out, there's no precedent for this. Like there's no mechanism for it. They couldn't find another example of it. So what I'm thinking is happening here, it's crazy, but what I'm thinking is happening is they probably got angry calls from Rob Bonta and others saying, make sure you kill this as soon as possible. Ask them to stay it because we don't need it. It could hurt us in Duncan, blah, blah, blah. But it is crazy to me, and it goes to show how bold and arrogant these anti-gun.
Well, and Kostas, I did a video on it, and what happens in these jurisdictions like District of Columbia in California is they're so used to winning. Yeah. They always get things their way. And when they actually lose, they don't know what to deal with it. And they literally cannot argue on the merits. They literally start throwing a tantrum. They start pouting. And, they were talking about the chaos and disarray that they've thrown the district into and stuff. And like I said, I invited any attorney from DC that wants to come on the channel and talk about how it's pure mayhem in the district right now. Hop on board. Let's talk about it. So.
Yeah. And look, I think the good news about it, well, you can good news or bad news, but I think, as I said at the top, if the DC Court of Appeals grants this stay on presidential value, we don't even we're going to lose the en banc. Like if they're going to do this unprecedented step of staying this, this crazy thing they've never done before, then there's no way we're winning the en banc, right? But I still think the ruling, even if that happens, is a positive development for us because it just further highlights the lengths these courts will go to not respect the Supreme Court. And maybe the Supreme Court won't care, but if they don't care, then we've lost anyway. And this does at least tee us up nicely for what I hope will be a good Third Circuit ruling. And that one will not be able to be reversed again because it already is an en banc ruling. So,
there it is, right in the flush. Well, I forgot what I was going to say. Anyways, all right. So let me tell you real quick what the dumbest shit is I read all month. And there was a lot of it, but it was actually out in Virginia where they're passing gun law after gun law after gun law. You see this frequently with tax laws. You see this sometimes when they pass the Obamacare. Congress exempted itself from Obamacare. The Virginia state legislature has actually exempted themselves from all of the new gun laws.
Did they? Is it all of them? I thought it was the one about the parking lots in the legislature.
There was one about the parking lot. And there's, I think, 2 other ones that they have exempted themselves from.
Right. And I think, I can't remember. I need to check with, I think Cam Edwards posted about how they might have rolled one back. I need to check, but yeah, it's arrogant and it's the same old, they're talking about how guns are so deadly and this and that. And then the first thing they do is exempt themselves from it while they're restricting our rights. By the way, in the state where they literally have a dead tyrant on their flag.
They are literally standing on a dead tyrant. Yes, that's exactly it's in their state seal. By the way, if you're out in Virginia and you guys aren't following Cam Edwards, you should be. He does a great job not only at covering the national 2A perspective, but he is a Virginia guy and he's very carefully watching that. So check him out. All right. Time for you to put in a little plug for SAF and all the great work you guys are doing for gun owners nationwide. It's our final segment of the day called What Are You Doing?
Sure, man. So right now I'm working on, as always, there's always amicus briefs coming because those are, pretty easy for me to do at this point. But we've got one coming soon in US v. Peterson, which is a suppressor case out of the Fifth Circuit. If you recall, that's where the Fifth Circuit basically said, okay, we'll assume without deciding that these are arms, but this is basically a shall issue registration scheme or whatever.
Yeah, it's a Bruin footnote 9.
Yeah, and which it's funny to say it's a shall issue scheme when the law was passed as a way to implement a cost prohibitive tax on suppressors. It just, inflation solved that problem.
We shall issue if you have the money.
Right. So it's crazy. But so we're working on an amicus brief for that. And another one, I need to check with my buddy Matt LaRosier about when Mr. Adamiak's petition's being filed, but we will do an amicus brief on that as well. And if and I expect it will, if Baird gets en banc'd in the Ninth Circuit, we'll do an amicus brief on
Baird
that.
v. Bonta.
Those are the 3 I have on my horizon.
Which one is Baird? What's the issue?
Open carry. Open carry.
That's right.
That one. They petitioned for en banc review. Both sides petitioned for en banc review for some goddamn reason. Anyway, that's another side note.
Well, the Illinois open carry bans before the United States Supreme Court right now.
So what's that one called?
It's got the best name ever. Mississippi Rod and Gun Club.
They didn't request a response though, right? So I think.
But Illinois always does that. If you go back and track, and Illinois is always like, what's the big deal? You don't need.
No. I'm saying but the Supreme Court hasn't yet requested a response.
No, they have not.
That means it's.
It's a bad sign.
Sometimes they'll do it at the very last minute, like literally the day before the conference. Sometimes you'll get a response request. So it could still happen. But if you go into the conference date without a response requested, it means it's getting denied usually. Anyway, so yeah, well, those are the 3 we have on our horizon. And I also I don't want to be too, reveal anything here, but I might be doing a little baby lawsuit of my own in-house at SAF. We'll see if that pans out.
All right. Well, that's a teaser. We'll
usually manage lawsuits and use outside counsel, but I think it would be cool to do some in-house when possible. It's, I think, more cost efficient too. So we'll see if that happens. And if it does,
you're getting a little bloodthirsty. You're getting a little bloodthirsty right now, aren't you, man?
I can't let everyone else have all the fun.
Exactly. That is a good lawyer. A good lawyer is the one that wants to go mix it up. That's a good lawyer. All right. Listen, just a couple of date reminders. Kostas, Hannah from Hannah Hill over at NEGR, we'll all be together Monday morning, March 23rd. We got our group of 5 cases on again. So join us 6:30 on the West Coast, 9:30 on the East Coast. And then we will be back for Behind Enemy Lines, Volume 7. Looks like we'll be back on Monday, April 14th. Sound like a plan?
Yeah, sounds like a good plan. And by the way, I should plug this too. Next week, next Tuesday and next Wednesday, the first day's Yucataki, the second day's Rhodey. I'll be live tweeting both those oral arguments at the Ninth Circuit. So
beautiful, awesome. And we will link up Kostas and SAF's X accounts down there, because when we have oral arguments going on, if you really want to get good live play-by-play with contemporaneous analysis, you should be checking out Kostas. My one announcement is Flint, Texas. I will see you Thursday. I'm taking a flight out of here at 12:30 in the morning, 30 minutes after midnight, flying to Dallas, getting in a rental car, driving to Tyler, then driving down to Flint, doing church security training, and then coming all the way back home the next day.
You are allowed to stay in Washington. I don't think they've banned you from the state yet. So
yeah, I know, but I got to be honest with you. When you go to states like Texas, now it's just out in Illinois, which is like going from China to North Korea, so it's not a big deal. But when I get to go, like next month, I'm going to be out in Tennessee, South Carolina, North Carolina. That smell of freedom. That's why I always spend time in Idaho too.
I'm actually taking my first trip to Washington next month, so maybe I'll see you.
Where are you going to be, man?
Bellevue. We're going to SAF headquarters. So, yeah.
Dude, I live like 5 minutes from there.
Okay, well, we'll meet up.
I'm going to come in. I'm going to come in, and I would like to actually speak to Alan Gottlieb once in my life.
Yeah, we'll talk
once
about
in my
it. We'll
life.
make that happen.
Yeah, Dave Workman. I'll hang out with Dave Workman all day, though. That guy's fantastic. All right, Kostas, thank you very much. Listen, for all of you who tuned in, thank you very much. We are Behind Enemy Lines. This was Volume 6. We'll be back Monday, April 14th for Volume 7. We will all be together Monday morning, March 23rd for WGLAM. Everyone, stay safe. Thanks a million. Kostas, thanks a million, brother. Appreciate it.
Thanks, Bill. Have a good one.